Hello everyone, I am live now and I'm just waiting for people to join in. Yeah, alright. So let me first introduce myself. I am Omita Unnarka. I am a practicing advocate. I have been working for last over a decade with various companies as in-house counsel, and it was a pleasure working with them. And today I am here to share a bit of my experience and let's have a discussion on this topic of law of torts and its evolution in Indian judicial system. So first of all, I would like to thank virtual lawyers to give me this platform, and special thanks to Janvi and Tarveen sir and all the other virtual lawyer members of the virtual lawyer to firstly establish such a platform wherein lawyers can come in and they can give and have this opportunity to discuss various topics of legal sharing this legal knowledge platform. It is really very nice initiative, and I am really thankful to virtual lawyers. So I think many people have joined us. Just give me 1 second. I guess there is some issue. Yeah. All right. So am I audible? I think I'm audible enough. Just give me a thumbs up or a wave so that I get a confirmation. All right, thank you so much, sir. So let's start up with today's topic, and I have kept today's topic very simple so that we can understand the concepts of tort and the principles thereof. So let us start with the definition of this word tort, how this word tort has come into existence, and from where and from which era does the usage of this word can be traced. So this word at times it is seen that I have seen many people saying that it's a Latin word, but let me clarify, it's not a Latin word. The origination of the word tort has come from the French system. So the traces of this usage of this word has been seen in the has been firstly recorded in the era of somewhere around 1350 to 1400 AD, and this was in French this word was used as wrong. I mean, the word wrong was used as tort. Even in Middle English, this word finds its usage in the form of the word injury. So the meaning of injury is again tort. And in Latin, in medieval Latin, this word was used as tortum. So we can say that yes, these words were this word has its existence for a long time, but yes, even being in existence for a long time, the law which is, or the principle of torts, have not been codified till this today's date. Even today, the law of tort is not codified, and it is a customary law as it was earlier. So this law is based basically on case laws and the various interpretations which various court of law have done, and it gets evolved by day to day era. So in today's definition, I would say that in India, what we use the definition of tort is as a wrongful act. So now, what is this wrongful act? So wrongful act, for the definition, or what we say under the law of tort, is a act which is other than the breach of contract, for which relief may be obtained in the form of compensation or damages. So here we are saying that this wrongful act, we have an impression of the word wrongful act which comes under the definition of word wrongful act is also there under the Indian Penal Code. So people may have this impression that if it is a wrongful act, then it should be penalized under the Indian provisions of Indian Penal Code. But why then this is penalized, or why we do have this law of torts as a different branch of legal interpretation altogether. So let me try to explain what is the difference between a tort and a crime, right? So the basic difference between tort and crime will be that the tort is a civil wrong. It is a breach of someone's private duty, whereas crime on the other hand is the breach of public duties. Now when we say this, then we also have to see what is the object of tort and what is the object of crime. So when we deal and when we say this, then the object of tort is to get compensation, and when we talk about crime, then the object of the action of any crime is to get a punishment, right? So Indian Penal Code talks about the various punishments which are there for any of the unlawful act or some hurt or injury has been made by one party to the another. Now the third important thing is that when we talk about tort, it is the individual can approach to civil court for the remedy. However, when we talk about crime, then the state shall take action and the prosecution shall be instituted against the wrongdoer, right? So these are the major differences when we are talking about a tort and a crime. Now the fourth important thing is when we talk about tort is a compoundable offense, saying thereby that whenever the party wants, they can withdraw the suit for torts and they can make a compromise also. But this doesn't happen in whenever someone is booked under the provisions of IPC. Why? The reason is very simple, that when we talk about crimes which are codified under the Indian Penal Code, these are the crime which are against the society at large. So to be very simple and to keep it very simple, tort, I would say, is a crime against an individual and a wrong against an individual. However, crime is a wrongful act which is done against the entire society. So it is a public wrong, and tort on the other hand is a private wrong. So now let us understand what are the general and basic principles of tort which this customary law has. So as I said, that law of tort is a customary law and it is not a law which is codified till date. We inherit this law of tort from UK, and therefore all major principles applied under the law of tort is similar to that of laws of UK. However, we shall see in our discussion how Indian judicial system has taken a shift from while interpreting these principles and while interpreting these doctrines of law of torts. So in the gist, I can say that we have borrowed this customary laws based on case laws from UK. It has evolved and has taken its own shape in the Indian judicial system. There are many case laws. I would be dealing only few of them because when I was going through and I was trying to compile my notes for this today's session, it was very difficult for me to formulate this particular entire session in this small time, because when we talk about law of torts, it seems to be very simple topic and the principles are very limited, but the defense which are taken in view of every principle and the exemptions which are there, and as I said that this law of tort is we have inherited it from the law of UK. So the law of UK again comes into picture, and the case laws can also be cited from law of the UK case laws can also be cited here. And it has always been happening that even now we have to go and see what exactly is the view of European courts while dispensing justice when we talk about any of the principles, like say principle of strict liability or absolute liability or vicarious liability. So whenever we talk about these principles, we have to go back to European courts, and we also have to see what the European courts are saying, what the courts of USA are saying, what any other courts in the world are saying, because even now in India we do not have any codified law for this particular thing. So only the principles which are there, those will apply, and the case laws you have to research and review, and you also have to see that how, while imparting justice, what all principles and what all questions have been considered by various courts while having while analyzing the factual disputes which is there between the parties. So let me try to figure out, and let me try to explain the first principle which the law of tort has, which is said as damnum sine injura. So now this is a Latin maxim which means damage without injury. So when we talk about law of torts, there may be a situation. See, we are talking about many situations. So the first situation will be where damage has occurred but there is no injury to any person. So it means that an actual loss has happened to a party but without any infringement of right of that particular party. So let me give an example of it. For example, if someone has started up, you are having a business of, say, a bookshop or a stationery shop, or say you are a food vendor having your stall in a street, and there is one competitor who starts similar kind of business on the same street. So of course your income shall be, or your profits shall be diminished because the other competitor's entry in that particular street. So but here when we talk, of course there is a damage which will happen to you, but there is no infringement of your legal right, because that particular person shall also have right to do business on that particular street if he has procured necessary licenses or whatever required permissions. So this is a basic example where we can say that yes, a damage has happened to you, but on this facts you cannot go to the court and ask कि भाई he has started a business there which is similar to the nature of business what I have, and therefore this person should be refrained from conducting his business. So these situations are covered under this particular first principle, which says that damage has happened without any injury, without any infringement of your legal right. So what will be the result shall definitely, as I said, that you shall be having less income, but yes, as your legal right is not infringed, you cannot sue the other person. Now coming to the second principle of law of torts, which says, now this is again absolutely reverse to this first principle which we have discussed. So this says injura sine damno, which means that infringement of legal right has happened but there is no actual loss which has caused to the party, right? So what will be the basic example of it? The most simple example, I have all taken very simple examples so that we can understand the basic principles first. So the best example is trespassing. So if someone trespasses your property, of course he has infringed your right to privacy and your right to hold and protect that particular property that you have. But yes, while doing so, as he has not caused any injury or loss to any other person or to you, then that means that there is no loss which has occurred, there is no actual loss which has happened, but yes, there is a infringement of your legal right. In such particular cases, as I said, that trespassing and all such acts where your legal right has been infringed, you can sue that particular person under the appropriate provisions of IPC also, and you also can get compensation in regards to this particular such acts. Recently, in recent events also, there have been law reporters, the news reporters who have been charged with this principle of trespassing. I guess every one of you might be aware. So I just to relate this particular principle to the current affairs. So I wanted to share this particular example. Now coming back to our topic, and let us discuss the third major important principle, which is principle of vicarious liability. Now this particular principle is also known as exception to the general rule. See, the general rule of tort or tortious liability would be that one person who has done wrong should be liable to make the damages, or he should be paying the compensation to the person whose right he has infringed, or the damage to whom he has caused the damage, right? So vicarious liability is a principle which is treated as an exception to this general rule. So why it is exception to this general rule? Who is covered or who is vicariously liable? Why we call this as a vicarious liability? Because this is a liability of the third party. But when we say that this is the liability, or the third party is required or is made liable under this principle to make the payment of the damages or the compensation, then what do we mean by this? We mean by this that the general rule of in order to have vicarious liability, we should know that the two persons who are there, they should have legal relationship between the defendant and the third party. So when I want to make another third party be liable for the vicarious, he should have the vicarious liability, he should take the vicarious liability. I have to first prove that yes, there is a relationship between the defendant whom I have made and this third party. So what kind of relationship it should be? So the relationship should be there has to be a legal relationship. There must be a relationship of a certain kind. The wrongful act which must be related to this relationship in a certain way. So saying thereby that one person, if he wants to make another this third party vicariously liable, so first he has to prove that yes, there is a relationship between this defendant who has done wrong and this third party. Because for example, the employer and employee relationship, or the master servant relationship, if the servant causes some damage to your property while conducting his duty, which was given by him by the third party, which is his master, so the master is liable to compensate you for the damages which has made or which has done by the acts of the servant, right? So at times it becomes very difficult to explain in this webinars, so I guess you guys will be understanding it. Again, as I explained this master-servant relationship, I will also give one more example of, say, a partnership firm. When we talk about a partnership firm, then the act of one partner, if some act of one partner is done, then all the other partners of the partnership firms will be equally liable, and they together have to pay for the compensation which is directed by any of the courts for the wrong done by any of one partner. Now, as I said, there are three major constituents for having this vicarious liability, for bringing any person under the principle of this vicarious liability. One, as we said, there must be a relationship of a certain kind between the defendant and the third party. Second, the wrongful act must be related to this relationship in a certain way. So saying thereby that the master and the servant, the relationship between this master and servant should be in such a manner wherein the master has directed this individual to do certain act, and while doing certain act, the rights of any third party, if are infringed, only then the master will be made liable, not otherwise. If that particular person, that servant, is doing something in his personal capacity and not in terms of the employment duties which are given by the master, or which are mentioned explicitly or impliedly, which can be covered under this particular master servant relationship or a partnership relationship. If it is not covered, then the principle of vicarious liability cannot be invoked, and this particular third party cannot be subjected to make the compensation. Third, now the wrong has been done during the course of employment. As I said that yes, the duties or the responsibilities or the acts which makes this damage should be under the course of the employment. If we say if it is his personal capacity, if his acts are covered under his personal capacity, then we cannot make this third party liable to give any compensation for the acts which are done by the servant or the employee in his personal capacity, right? So I will give you one simple example for differentiation between the vicarious liability, how we can differentiate what will be covered under the vicarious liability. For example, if I am going in a car, my driver is driving me in that particular car, and he jumps the red light or he dashes someone else's car, then because it's my car and he is under my employment and he is taking me, I have asked him to take me to some another place, so I would be liable to compensate the another party if some damage has been done to someone else's car. Now this is when I am there, it's my car and I have my driver doing this particular act. If I book a cab or a taxi and similar incidents happens, then in such situation I shall not be liable to make any compensation or any payment to any other party if even he jumps the red light or if even he bashes someone else's car, right? So by this example we can clearly make out as to why and at which situation the third party, which becomes me, I am made liable or I am subjected to make the payment of compensation or damages to any other party. So this is basically the principle of vicarious liability, right? Now this traditional view, traditionally when we talk about vicarious liability, then there are two principles the two tests which needed to be taken care of by the courts, or they used to take the facts and they used to test the facts on the basis of these two principles. The first is called as test of control and the second was hire and fire test. So these were the traditional two tests. Now, by the word itself, it says when we talk about the test of control, it means that what kind of control does the master has on the working or on the execution of work of the employee. The second test, again it by virtue of its own words, we can understand that hire and fire means what rights will the master has for hiring that particular employee, and how well can he fire that particular employee. So if both this test were qualified by if the facts of the case would have qualified both this tests, then the third party was made liable to for making the compensation under the provisions of this vicarious liability, under the principles of vicarious liability. However, in the modern view, which our Supreme Court in Dharangdhara Chemical Works versus State of Saurashtra has also laid down, that this test of control has no longer this test of control can no longer be a guiding principle to decide the application of vicarious liability, as the control of the master to supervise the work done by his employee shall change or vary depending on the business to business. So the Supreme Court, our Indian Supreme Court, has also said that this principle of the test of control is no longer can be taken as a guiding principle. And why? Because the nature of the nature of business has changed, and when we talk about the changing business nature of business, I would say that the nature of business has become more complex, and it becomes very difficult to understand that how and what were the roles and responsibilities of the employer, and how much control was the employer having on the acts or the execution of work when was done by the employee. So now, according to the modern view, now what does the modern view say? See, we have, again, as I said, the Indian judicial system has taken a shift from the traditional view. So here we will see how the shift has taken place under the Indian judicial system. Now, according to the modern view, the control will no doubt, I mean, this test of control will be there, but along with the test of control, there are many other, the many other things which will be considered. So there are many other tests which needs to be qualified to bring any particular person under the purview of vicarious liability. So what will those be? We will I have jotted down certain points that what such questions will be, which the court should consider whenever they are adjudicating this principle of vicarious liability. The first question, according to me, shall be whether the man performing the services provides his own equipments. Second, I mean, this is case to case basis. When I talk about equipments, that means goods or any other working appliances also. Second will be whether the person hires his own helpers. So in case if the employee is also again further hiring some employees, then the main master shall not be having so much of control on the helper's helper, right? Now the third question will be what degree of financial risk he takes. So if the employee himself is taking a lot of financial responsibility, or he is getting a lot of financial rights under the terms of the relationship, then the master shall not be made liable. So his liability shall be curtailed to the amount of his financial risk what he takes under this particular relationship. Now the fourth important thing will be what degree of responsibility for investment and management does he has, right? Similarly, as we discussed, this again comes under the same line. The fifth important thing will be whether and how far has he got an opportunity of profiting from sound management in performance of his tasks. So as I said, that if that particular employee is getting a lot of financial worth from this relationship, this kind of if there is this kind of relationship wherein the employee himself is getting a more benefit than the master or equal benefit, then the responsibility or the liability shall also be curtailed under similar situations or similar likewise. Now in today's world, as I said that today's world, the business has changed, the level of complexities of business have changed, the people have come across and they have come with such business ideas wherein they try to avoid legal duties and liabilities, and therefore now it becomes the duty of the court to investigate the truth, and for investigation of this truth and to give justice or impart justice and to bring out real culprit, they have to they have to take many tests into consideration. Few of these tests, as I would say that the courts have considered is first is the control test, second will be integration test. Integration test meaning thereby what is the organizational integration of the employer and the employee. So that, as we discussed this in the questions above, this principle of integration test again is a part of the questions which I have asked, which normally the court asks when you come up with this facts wherein the vicarious liability is considered or has to be interpreted by the court. Now the third will be economic reality test. As we said that economics of the parties shall also be considered properly, and then the evaluation shall be made that which party shall be liable under this principles of vicarious liability. Then comes the hire and fire test, the course of employment test, or authorized acts which acts are authorized by the master under the agreement if they are having between the employer and the employee, or which are such acts which are explicitly prohibited to do, and even if these explicit prohibited acts are done by the employee and which causes damage to any third party, then in such particular situation the principle of vicarious, the third party shall not be made liable to make any compensation under this principle of vicarious liability. So this were the this was the discussion what we made for when a single individual who is who has to be made liable for any vicarious liability. Now coming from this individualistic perspective to the perspective of state. So when we talk about vicarious liability of state or the government, how government is also vicariously liable, and in which situations the government shall be vicariously liable, and how this vicarious liability of state has evolved. So the concept of vicarious liability in India got evolved by East India Company in say 1858. So when we talk about this 1858, before 1858 the state was not at all made liable for any of the acts if we do. As earlier, if we see that in India there was a saying that king can do no wrong. So even that applies now to a great extent, that state cannot do anything wrong. But yes, when such wrong has been done by the state, then the state can sue and can also be sued. Now if you see Article 300 of the Constitution of India, it gives this right, or it gives this liberty to people to sue the government also if some wrong has been done to them by the government, right? So now if we talk about that the state has become or is made liable under the provisions of Constitution, then why we say that the law is not codified? See, the law is not codified. We say that the law of tort is not codified because these principles of vicarious liability or the strict liability or absolute liability are nowhere defined. Those are only the principles which are laid down still now, but under any of the Indian provisions we do not find any codified thing for what provisions or any sections that in such particular situation this will happen, or this shall be the level of compensation which will be given. There is no such levels of compensation which have been defined. For example, if we see about the Indian Penal Code, there are two kinds of punishments which are given. One is the punishment of 3 years or 4 years or whatever. There are various acts and various punishments, and also there is a provision of fine which has been given or defined there. So it's a defined limit of fine which the court can impose on the wrongdoer. But here under the principles of tort there is no definition of the compensation, or what kind of compensation shall be and how much amount of compensation shall be given in which situation. So this is absolutely the liberty of the courts to decide on the compensation, which will again determine the determining factors will be various, which we will see what all will be the determining factors of damages which can be claimed under the law of torts. So just give me a second. So as coming back to vicarious liability of the state, when we talk about vicarious liability of the state, as I said that we inherit this law of tort from law of UK, then we also have to see that when did UK brought the crown under this when did they say that the crown can also be made liable for any private wrong which has been done by any of the individuals. So the Crown Proceeding Act of 1947 was the first enactment which was made by the law of UK, under the law of UK, to bring the crown under the crown was made, under which the crown was made liable as much as a private individual. In India, when we say, as I said, in India, Article 300 has taken care of it, and now we can sue the government, and also the government can sue, and they can also be sued. So this has come in effect only in 1950, when the constitution was taken up. Now, what does Article 300 says? Article 300 though specifies that Union of India or the government of any state can sue or can be sued like an ordinary person, still there is no clarity or clear law while dealing these principles of vicarious liability. As I said, that even today, though this Article 300 gives power to private individuals to sue the government for any wrongdoing, still there is no clarity as to what amount of what shall be the percentage of vicarious liability which the government shall have, or what kind of damages or the compensation which the government has to pay. So, first landmark case in India relating to this particular vicarious liability, I would say, was the Peninsular and Oriental Steam Navigation Company versus Secretary of State of India. Now, this particular case was before the Constitution was enacted. So, even before the Constitution was enacted, the Supreme Court in this particular case has classified the two different types of functions of the Secretary of State. Now, the first function was the statutory function, and the second was the sovereign function, and the second was the non-sovereign function. So, when we talk about the sovereign functions of the state, these are those functions for which the state cannot be made liable in any way. So, whenever the state is performing, or any of the officer of the state is performing any sovereign function of the state, and while performing this sovereign function, if any damage has been made to any third party, then that third party cannot sue the government for any damages, because such damage is made while performing or while implementing the sovereign functions of the state. Now, what shall be these sovereign functions? The first sovereign function shall be the defense activities, or preserving the armed forces, or maintaining peace, or peace and war, or diplomacy. So these kind of acts are covered under the sovereign functions of the state. Now, what then will be the non-sovereign functions? So when we define, so the Supreme Court in this particular case has also defined that any other act which the state is doing which are not the sovereign function shall be termed as non-sovereign functions. So for this non-sovereign functions, if any damage has been any damage is made by the officer of the government while performing any non-sovereign functions, then the government can be sued under the provisions or under the principles of this law of tort, right? So there are many other cases in Indian history or in the history of Indian judicial system, wherein this principle of vicarious liability has been defined and redefined by the Supreme Court. The best examples for them shall be State of Rajasthan versus Vidyavati, or Kasturi Lal Ralia Ram versus State of UP, or Neela Bain Behra versus State of Orissa. See, these are some landmark judgments, and wherein the Honorable Supreme Court has dealt with the sovereign and non-sovereign functions of the state, and this has made clear as to under what acts the government can be sued, and under what provisions the government cannot be sued. So now I guess we have covered the entire big chunk of the principle which makes the third party liable, which is the vicarious liability. Now moving down to the fourth principle. Now the fourth principle is volenti non profit injura. So sometimes, now what does this mean? This means that sometimes it may happen that a person may suffer damages when he consents to some act. So there is a consent to some act, and after having this consent or the knowledge, if you are having this knowledge of possible risk or the damage which you can have, even then you have given your free consent to the another person to undergo the same, and then you incur some loss or some damage. So in such situation you cannot sue the another person, because you already had this knowledge, or you already had the knowledge of the possibility of the damage or the risk of the damage that can happen. So this was your calculated risk which you have taken, and therefore in such situation the third party or the other party cannot be sued, because he has already opened up himself, and he has given you entire description as to कि भाई this can be the possible risk and this can be the possible damage which can happen. And even after that, if you given consent, then in such particular situation there is no remedy available with you to go and sue that particular person, right? So now the main factors, the deciding factors of this particular the doctrine of under this doctrine are two. One is the consent should be given the consent should be given freely and voluntarily. So these are the principles, or these are the factors which needs to be considered by the court of law while dealing with this principle. The best example of this is the medical liability, which at times people come up and say that this particular doctor has not performed his duty well, and he should compensate, the doctor or the hospital should compensate us. So in that particular situation, the doctor shall come up with the defense, or the hospital shall come up with the defense, that they have signed this particular form under which we have clearly and categorically mentioned that this is a kind of risk, or the risk of life, or the risk of the patient's medical condition can be such, and the hospital will always firstly they will get a form signed from you, and they will take this. Why this form is signed is because if such situation happens where the damage or the loss has been occurred, then they can take this as a defense before the court of law, that this form was signed and we have already made the other party aware of what is the possible risk and risk which can happen, and they have given their free will. But the courts in India, I would say the National Commission at times has taken this view that in this medical negligence cases, the situation of the family of the patients is such that they have no other option than to sign that particular form, and that is the reason why they have said that yes, the hospitals are liable for damages if some wrong has been done by the doctors or any of the medical staff in that particular case. Even at times the doctor have been made liable along with the hospitals. So therefore I said that the main factors under this particular principle is the consent, which consent should be free, and second, it should be voluntary. Now the second most important thing is that the claimant should be fully made aware of the risk involved and the nature and extent of that particular risk. So it shall again be that if the person is not made aware of the risk or the extent of the risk which is involved in this particular particular act, then the person, of course, if he suffers any damages and he was not aware of the extent of risk, he can go and ask for, and he can go before the court and sue the other party, and the party will of course take a plea that yes, he was made aware. So the proof of this particular point shall be very important while deciding on the compensation, right? So as I said, the consent of the plaintiff / claimant shall be used as a defense by the defendant. In such cases, the burden of proof is on the defendant to prove that the consent granted was voluntary and was of free will. So this shall be the burden of proof. As I said, the burden of proof lies with the defendant. So defendant has to prove that the consent is given freely and voluntarily. So now, as we say that this consent may be expressed or implied. However, there are certain limitations on the application of this rule. See, as I said, each of the rule has some exemptions, each of the rule has some exceptions. Even this particular rule has some limitations. For example, the limitation shall be rescue cases. So rescue cases where a person is trying to rescue the other person, and in such while rescuing, if some damage is some injury or some damage happens, then in such particular cases you cannot go and sue the person who was rescuing you, right? So he was basically, his intention has also to be considered, that what intention with which he was trying to rescue you, it was for your benefit and not for his personal gain. Or for example, the second example or the second exemption or second limitation to this particular am I audible? I guess there was some. Hello, am I audible? Please give me a confirmation. Am I audible? Okay, all right. So I guess there was some confusion. I was on this topic of voluntary non-profit injurer. I guess I had completed till there, or do you want me to go back and start up? So please give me a confirmation that was I audible till now, or should I repeat some of the portion if it is not? Okay, I guess so. I'll start from where I had left. I was talking about limitations. Limitations to this particular rule. One was the rescue cases, second was illegal acts, third was negligence of the defendant. So if there is some negligence which is done by the defendant himself, then okay, all right, thank you so much, Raghav. So third was the negligence of defendants, and fourth is contributory negligence. So these are the four exceptions or limitations to this particular rule. So therefore, while allowing the defense, the court have to ensure that the condition of the defense are fulfilled and the act is not one which falls within the limitations which are imposed on this defense, right? So now let's come up to the again very important, I would say, principle or the doctrine, which is doctrine of strict liability or absolute liability. See, there is a very fine difference between this strict liability and absolute liability. So let us first understand what is strict liability. Now these two principles of strict liability and absolute liability levy liabilities on industrial and commercial ventures when their business activities cause damage to any of the public. So when we talk about strict liability or absolute liability, this is specifically dealing with the liabilities of any commercial venture or any business any business or industrial company. Right. So this means that liability shall arise even if the intention was not to make any damage. See, when we talk about any industry, then the industry of course wants to make profit, but its intention is not to damage the well-being of any another person, right? Because they want to grow. But yes, when we establish industry, then there is various types of the losses or damage or injury which they intentionally not intentionally, they unintentionally they make to other people staying nearby also. For example, the best case of this would be the acid company which was established near the banks of river Yamuna, and because of the fumes which used to come up from that, the chemical fumes which used to come up from the this factory, it has in a way it has damaged the Taj Mahal, and therefore that particular chemical factory was stopped. That was stopped from working. because they wanted that the Taj Mahal should not, it is the world heritage, and therefore the courts never wanted that any damage or injury should happen to this Taj Mahal, and this was the best case of strict liability imposed, and under the ambit of this strict liability, the chemical factory was stopped from working. So again, while explaining this, I would say that this means if a damage or loss is done by any business or commercial activity who has followed or has taken care of all the required precautions, even if you have taken all the required precautions, still you, under the provisions of strict liability, if any damage or wrongdoing has been done to any other persons, then this company or this commercial activity shall be strictly liable to make good the compensation or make good the damages which they have done. Now the best example for this, again it's a tragic example, which was the Bhopal gas tragedy, which has happened in December 1984. So the principles of strict liability were again imposed here, and the company was made liable to pay compensation to all the residents nearby. So the principles of the strict liability originates from the famous English case law, which is Ryland versus Fletcher. I guess every one of us have in detail read about this particular case law. Now there are certain exceptions to this general rule. I'll just try to cover it up a bit faster, because the time is already ticking off. So there are exceptions to this general rule, or the defense which can be, these are the defense which can be taken under the purview of this particular doctrine of strict liability. Those exceptions are 5, I would say 4 to 5 exceptions. First is the act of God or natural disaster. Second will be the lawful acts of the third party. Third would be the plaintiff's own default or the fault of the plaintiff himself. The fourth will be plaintiff's consent, and the fifth will be the part of statutory duty. So if any of the act which has created this damage to some person, the best defense by the wrongdoer can be these: that this was an act of God, or this was a wrongful act of any third party and it was not his fault. And the third will be that it was plaintiff's fault and not the person's fault. And fourth will be that there was a consent which was given by the plaintiff himself, and therefore the plaintiff cannot claim for any of the plaintiff cannot sue the defendant, because it was his by his own consent. And the final thing would be that it was this particular act which he has done was the statutory duty of that particular person. So as we have already seen the sovereign and non-sovereign function, those will come into picture. Now talking about the principles of strict liability, we also have to, as I said, there is a minor difference between strict liability and absolute liability. So what will this be? See, absolute liability means again strict liability minus this exemptions or minus these limitations. The principle of strict liability in a, I would say, more stricter version is the absolute liability, where even if you have taken, you cannot take any of this defense which you can take in the course of strict liability. Under the provisions of absolute liability, you cannot take any defense. The best case of absolute liability was MC Mehta versus Union of India, and the Indian judiciary tried to make a stronger effect again from this Bhopal gas tragedy. We have the Indian judicial courts have taken a very strong opinion, and the doctrine of absolute liability was evolved in oleum gas leak case. In the oleum gas leak case, this doctrine of absolute liability is much more stronger than the doctrine of strict liability, and it gives no ground of defense to the defaulter. Now even if the defaulter has taken all the necessary required precautions, or if he has no intention, even then when the court applies this principle of absolute liability, the wrongdoer has to make payment of the compensation. So this is the strongest, or I would say the strictest principle of tort. And if the court takes this view, it is even with changing times and economic, business, or the environment, we have brought in the Indian government has brought in various enactments such as the Consumer Protection Act or the Motor Vehicle Act, or now recently they have come up with this RERA Act. So all such kind of new enactments, they again gives this law of torts, or the principle of law of torts, shall be taken or considered under this enactments, and justice shall be imparted to the customers or the persons under this various Consumer Protection Act or Motor Vehicle Act, and justice shall be imparted in such particular ways. Even if we talk about the National Green Tribunal, then National Green Tribunal has again imposed strict liability over various companies. For example, LG Polymers was made liable in this Visa gas leak. Now the only question was whether it should be made liable under the strict liability or the absolute liability, so that we will discuss on. So I guess we have covered the various major principles of law of torts. So in case if anyone has any questions, please let me know. In the event if there are any questions, then I guess because people can ask me the questions in the comments, and I will reply to them in the comment section. So thank you so much, virtual lawyers, for today's session, and I guess I was clear enough. I think there was certain technical difficulties, but we have overcome it. So thank you so much for today's session, and thank you so much for listening me.